I'd also like to thank my co-presenters, Marty Shankman, Steve Horowitz, as well as our audience for joining us. We know that you have many webinar choices, so thank you for giving us your time. With that, let me tell you that my objective for this next half hour is to just basically make you aware of the 4 living benefit strategies of life insurance policies that most of your clients are absolutely unaware of, and many of you may not be aware of yourselves. So let's start with the agenda. So what I'm going to be talking about are what are living benefits of life insurance policy. And part of that, as far as I'm concerned, is matching and selecting the death benefit or living benefit, because policies have both. I'll talk about an overview of the 6 types of life insurance policies, and also talk about the overview of the long-term care industry, because the long-term care insurance industry, I should say, because that did drive 2 of the living benefits that I'll be talking about. Be talking about the Pension Protection Act, which invited the long-term care industry and the annuity industry to take advantage of some of the living benefits. The 4 benefits are being able to pay for long-term care expenses from the death benefit of the policy, tax-free. Also be talking about the ability to transfer life insurance gains to long-term care or an annuity, also tax-free, basically similar to 1035 or 1031 exchange, and the ability for the insured owner to sell a life insurance policy. The last living benefit is using tax deferral to be able to supplement one's retirement. So first choice is death benefit or living benefit. Well, everybody's aware of the traditional death benefits of life insurance policies, providing family income, paying off debts, future liabilities, some future tax liabilities created as a result of the Secure Act, which is another subject altogether. Being able to talk about providing an educational fund for our children, and also funding buy-sell agreements for business partners. That's what we're not going to be talking about. What we are going to be talking about are the living benefits of paying for long-term care costs from the death benefit of an insurance policy, a tax-free exchange into a long-term care policy from life insurance and or an annuity, as well as being able to sell a policy that benefits the insured while he or she is alive, and lastly, to be able to supplement retirement with tax advantage payouts. So how many times do people buy a life insurance policy during the course of a typical lifestyle? Well, when they buy a house, when they have a child, when they have a second child, or have a bigger house, a bigger mortgage, if they start a business or apply for a loan, if they have a business partner, having a buy-sell agreement, and basically if and when they want to create a legacy for the next generation using life insurance. And lastly, if they want to prepay their federal, state, or inheritance taxes. Three actually in yellow are the living benefits, where they make their first appearance. And that's when people want to set up a supplemental retirement plan to supplement their retirement, or when they want to use life insurance to pay for long-term care costs. This is not when they buy life insurance, but the third area that we'll talk about is when they want to sell their policy for cash today. So life insurance is an asset class. Most people aren't aware of the living benefits because they don't use their life insurance to pay for long-term care expenses. Most people surrender or lapse their life insurance coverage when they no longer want it or when they no longer can afford it. They don't necessarily think of selling it. Most clients don't use tax-deferred benefits of a life insurance policy to supplement their retirement. Most people use stocks, bonds. This is an interesting spot to be able to diversify a little bit further. And most clients don't transfer the life or annuity gains into a long-term care policy. They just basically pay the taxes on their annuity gains, and that's the end of it. And most clients really pay very little attention to this asset class compared to their stock, bond, or real estate portfolio. So, being able to match a policy with clients' objectives. There are 6 policies, and what I'm going to do is very briefly go through those that provide a living benefit, and I'll just mention those that provide a death benefit. Term life insurance, most popular life insurance product to maximize the death benefit. It's also the least expensive. Why is it the least expensive? Because only 2% of term policies ever get paid out. Why is that? Because term policies basically end anywhere between age 80 and age 82. And a term policy has a few guaranteed items. What are those guaranteed items? One, the death benefit is guaranteed. Two, the premium is guaranteed. And three, the duration of how long that coverage lasts is also guaranteed. Term insurance can be purchased either on an individual basis or on a group association term basis. Individual term policies can be converted, transferred if you leave your place of employment. However, group association term policies are a ticking time bomb waiting to happen. And I know that most of you have some form of a group term association through the ABA, through the New York State Bar Association, whatever the case may be. If you have a group association policy, you might want to request a particular article that I'd written on the subject. Term insurance is not for accumulation. Whole life insurance is the second. Whole life insurance has been the workhorse of the industry for the last 180 years. Policy accumulates cash value, provides the least amount of death benefit for the maximum premium that you're paying. It's a good conservative product for accumulation. And when I talk about cash value, I just need to take a moment just to explain what cash value is. For example, person pays a $10,000 premium. There are expenses, administrative expenses, fees, medical costs to underwrite the policy, commissions. So let's assume that it's $3,000. $10,000 minus the $3,000 administrative costs leaves approximately $7,000. In a term policy, most term policies guarantee in the vicinity of a 3% payout. So that $7,000 each and every year will grow by 3% guaranteed, on and on and on, so on and so forth. Next policy type is something called an indexed universal. A little bit different. It doesn't have a guaranteed return basis. Instead, it gives you the option of picking a specific stock index that you choose. And then on this particular type of contract, in exchange for caps of, say, 75% of your gains, if there's a loss, you don't suffer a loss. So the returns won't decrease if the stock index that you chose declines. It's an excellent vehicle for maximum death benefits, for accumulation and distribution planning. And again, what does the cash value look like in a index product? Same $10,000 premium, same $3,000 expenses, leave $7,000, but the cash value growth is dependent on the specific stock index that you have chosen. In this particular policy, 75% of the gains and 0% of the losses. Variable universal policy works somewhat similar, only there are no guarantees. The client assumes 100% of the market risk. It's an excellent vehicle for someone who wants to put more money into a policy than they need to, because the overfunded policy accumulates tax deferred, and then it can be distributed tax-free in terms of tax-free planning. It's a wonderful product for people wishing to assume and obtain a high rate of return. Private placement, who we'll hear from Steve in a little bit, is basically similar to a variable universal, but it's basically used for the ultra and for the high net worth client to overfund and accumulate funds at a specifically lower cost. And Steve will touch on that a little bit further down the road. The fifth type policy is a non-guaranteed universal, which currently makes up about 55 to 60% of the marketplace. It's the only option to be able to pay less than whole life and yet still have permanent coverage. The non-guaranteed product, ever since it came into being, non-guaranteed universal product, ever since it came into being in the early 80s, has really been one of the significant workhorses of the insurance industry for the last 20 some odd years. I should say for the last 40 some odd years. People assume that the interest rates on these contracts would remain constant. And if you recall, back in the 80s, we had interest rates as high as 21%. So most policies were purchased years ago when the interest rates were significantly higher. And as the interest rates decreased, people should have increased the premiums, but no one told them. And they should have paid a higher premium, but they didn't. And as a result, many policies today are increasingly expiring prematurely. And we'll talk about that in a few moments, a little bit more in detail. The sixth option is something that came about in 2003, and that is a guaranteed universal. When the industry was sick and tired of hearing complaints coming in from people who had policies that heretofore they didn't realize were non-guaranteed, the insurance industry finally began offering a guaranteed universal. It's a wonderful product, and today, over the last 20 years, that has basically been the current workhorse of the insurance industry, to be able to provide minimum accumulation as the insured assumes zero risk, and the death benefit and the premium and the death benefit, the premium, and the duration are all guaranteed. Okay, so a word about long-term care today. It's one of the fastest growing group benefits for employers and employees. It provides tax benefits, it provides tax credits, and it provides discounts. It also, of course, provides the independence that an individual has and the peace of mind they have for having one of these policies. The benefits can be discriminatory, and people want the benefit, but they basically consider the costs too expensive. And as a result of that, the industry basically got a bad reputation, which was as a result of some incorrect pricing assumptions, because the underwriters and the actuaries, I should say, had no clue how to deal with this. It was brand new. So they went ahead and they began using some incorrect utilization assumptions. They thought that far fewer people would use this. They thought that people would be giving these policies up at the end of 5 or 10 years, similar to what they do with life insurance. They also assumed that the interest rates would stay much higher. Well, this led to significant premium increases, and it led to consumers' fear to purchase. And it didn't address the consumer's major concern. If I don't use this stuff, I'll lose it. And that basically resulted in only a 9% penetration into the marketplace. Well, the insurance industry is not a stupid industry. So what they did is they collaborated with the government. And the insurance industry decided to increase private ownership of long-term care insurance benefits. Why? Because it accomplished two things. It provided consumers with the price guarantees against rate increases, and it also provided the insurers profitability, because if more people would have this coverage, the insurance industry would make more money. It was also good for the government because it reduced individuals relying on government Medicaid costs. So for the first time, as a result of the Pension Protection Act, for the first time, it allowed what they call linked or combination or hybrid life insurance policies to pay long-term care costs directly from the death benefit on a tax-free basis. It also allowed for tax-free transfers from life insurance and annuities to pay for long-term care costs. And most importantly, if an individual didn't use the benefit during the course of his or her lifetime, then the beneficiaries would receive the death benefit. So, to summarize for a moment, the Pension Protection Act allows tax-free exchanges on the gains. Trillions of dollars of annuities out there. On the left side of the screen, if an individual had a $50,000 annuity and had a gain of $50,000, they would first have to pay tax of approximately $20,000, 30%, on that $50,000 gain, leaving an availability of only $80,000. However, after the Pension Protection Act, that same individual with a $50,000 basis and a $50,000 gain, well, if that $50,000 gain is used for long-term care, then that $50,000 gain is not taxable, providing the entire $100,000. And this can be transferred to a long-term care contract today, which benefits the insured today. Just the schematic on the left side, you'll notice that there is no long-term care options. On the right side, the 1035 exchange rules now allow an annuity to go into long-term care, a life insurance to go into long-term care, and a qualified long-term care, which is not the name. This is the schematic for the gains on the annuities. Keep in mind, trillions of dollars of annuities being held by your clients, and most of them are using it for the wrong reasons, because when it's the end of the day, beneficiaries, before they receive the benefit, they're first going to be paying taxes. How does the total living coverage work? Very simply, somebody puts in a $100,000 premium, somebody gets a $159,000 death benefit, or they can wind up turning that $100,000 into an almost $500,000 long-term care benefit, providing basically $6,000 a month for 6 years. That's just on the 100,000. Okay, as I mentioned, there are two types of long-term care coverages. One is the traditional, where a person pays the premium on an individual on an annualized basis, using a typical example of, say, $200 a day for 3 years plus inflation for a female 65. This is the use it or lose it option. The annual cost is approximately $3,200, less discounts, deductions, and credits. This is just $3,200 is the gross premium. Please keep in mind that there's a 20% New York State tax credit for anyone purchasing a traditional long-term care policy. So in 20 years, that $200 a day becomes $500,000 with inflation, and it's $500,000 is available to pay claims. The other side of that coin is the same individual could have purchased a $500,000 life insurance policy called a linked or combo or hybrid for that same female 65. That cost would be approximately $6,200. So individual can just do the math and figure out whether it makes sense for him or her to have the traditional policy or to have the combo policy. Combo policy costs approximately $3,000. Is it worth $3,000 annually for a female 65 to purchase a $500,000 policy? I think yes. But again, it depends on the ages, and it depends on you and your client, and of course, client's health. So what to do with an unwanted policy? Life insurance becomes too expensive because non-guaranteed universal life policies have been neglected. So when a policy is no longer needed or no longer able to be afforded, and as an example of that, mortgages are paid off, buy-sell insurance is no longer needed, or when state taxes are no longer an issue, people look at their life insurance and they say, why is my life insurance increasing or decreasing in the duration? Or why am I getting a letter from the insurance company telling me that I have to pay twice as much? Well, the reason is very simply, most people were not aware that the life insurance policy, the non-guaranteed policies, were non-guaranteed. It was just considered universal life insurance, and people assumed life insurance would be guaranteed, just like term insurance was, just like whole life was. That's not the case. It's the trustee's responsibility to manage the policy, not the agents, not the insurers. People should have increased the premiums, but they didn't know that they should have. They treated life insurance as a buy and hold asset, basically putting it in the bottom left-hand drawer and then letting it sit there and not looking at it until they got that letter from the insurance company saying that you need to pay a higher premium or your policy will be expiring within the course of XYZ. So as a result of reduced interest rates, coverage today is expiring prematurely. Very briefly, the Wall Street Journal, I've contacted Wall Street Journal several times over the years, letting them know that it's a problem. Wall Street Journal has run several stories, and they basically say, yes, people's life insurance is expiring prematurely for the various reasons on the slide. The insurance industry is finally acknowledging that there's a problem, and this is from General Counsel for the Insurance Marketplace Standards Association, saying, while the insurance industry hasn't publicized the issue, there is a growing concern of the industry about lapsing universal life policies. That should have been on the front page of the Wall Street Journal. So if there's a problem with a policy, client needs to obtain, or a agent for the client needs to obtain, an annual summary statement, historic projection, and engage an independent broker to obtain and to evaluate that information. Client's options are to reduce the face amount, to pay a higher premium, if possible, obtain a new guaranteed contract if they're qualified, if their health allows it, or to be able to sell the life policy as a life settlement to an institutional investor or some combination of the above. So most people, when the coverage is no longer needed or wanted, they either keep the coverage till the cash value runs out and the coverage runs out, or some people surrender the policy for the remaining cash value from the insurance company. But a far better alternative for somebody over age 70 and for somebody in standard health with a policy of at least 100,000 is to be able to sell the policy. Again, Oliver Wendell Holmes U.S. Supreme Court Justice in Grigsby versus Russell, placed the ownership of life insurance same as you would for a car, a home, boat, or any other piece of property available to be sold. So how do you turn a bill into an asset? Example, in this particular situation, male, age 86, had an $800,000 policy with a $26,000 premium. Insured borrowed 100% of the cash value, also borrowed the dividends to pay the premiums. And now the insured had a $52,000 taxable gain, and the coverage was set to expire at age 87 next year. Following year, his premium would have increased to $29,000, and then it would have been increasing 4 to 5% each and every year. So after an initial consult, the client was informed that a life settlement is an option. We ordered the life expectancy reports to try to figure out how long this individual would remain alive for. Sounds gruesome, but that's the way the life settlement industry works. A life settlement offer was obtained from an institutional investor, and the client wound up accepting $188,000 life settlement cash, plus he was able to stop paying the premium, plus he still had the life insurance, the residual life insurance, I shouldn't say the residual, the life insurance over all of those years. Had he passed, the beneficiaries would have received $800,000. So basically, a life settlement is an alternate exit strategy. When the benefit is no longer needed, again, tax is no longer needed, businesses are sold, or buy-sell is no longer required. When business loan is paid off. Another recent example is a client had 3 children, and he didn't want to wait until he asked those children to receive a gift from him. So the client was aged 82. He had a $5 million death benefit, and his cash value was $1.3 million. Fortunately, his attorney referred him to me before he turned in the policy for cash value from the insurance company, and the client wound up accepting a $1.8 million cash offer, basically $500,000 more than he would have received had he turned that policy in for its cash value. Some new information on life settlement. Yes, an individual does have to be over age 70. Yes, the declining health is preferred. 100,000 is a base. Term insurance can also be converted if it's not past the conversion age, and that's an important point. Usually age 65, 70, life insurance policies can be converted from a term policy into a permanent policy. Now there's a new market for any type of guaranteed universal policy. If anyone has a guaranteed universal policy, a life settlement institutional investor will purchase that policy, regardless of the individual's health. Even if he or she is in excellent health, they figure that if it was good enough for an insurance company to provide them the coverage, then it would also make sense for the life settlement institutional investor to purchase that coverage. Supplemental executive retirement plans is the 4th living benefit, and it allows for personal accumulation strategies using either the whole life, the index universal life, the variable universal, or as Steve will talk about in a few moments, the private placement life insurance. Basically, it offers tax-deferred accumulations. The loans and surrenders provide tax-free distributions that never have to be repaid as long as the policy survives the insured. Again, there are minimal reporting or administrative requirements involved. The ability to discriminate amongst employees is there. An individual can do this for a key employee as a deferred comp. Small business, many corporations provide some form of deferred comp for key executives. And don't forget, the key employee can also be the owner, the employer themselves. Example, individual 45 deposits $25,000 a year till age 65, 20-year period. In this particular example, I used a 5.86% return. And this is usually on some sort of a variable universal policy where a 5.86% is considered conservative. The individual purchases that $500,000 policy, but he's or she's doing this because from age 67 to age 82, that payout would provide a $77,596 payout each year. And that's as a result of loans and surrenders that, as I say, never have to be paid back as long as the policy survives the insured. So the individual starts out with a death benefit of 1.67 million. It decreases over the years as the income is taken out, starting at age 67. But at age 82, the death benefit is still 257. So if you do the math of 15 years at 77,000, it comes out to $1,160,000. There is no gain. There's no tax due on that gain between the 500,000 and the 1,160,000. 660,000 is a tax-free gain. Plus, they've had the life covered, and they never pay a tax on that $660,000 gain. Private placement life insurance is basically similar to a variable universal, only in some cases you can add a 0 or 2. With Ppli, one can defer gains in any permanent policy, but Ppli has lower costs. Ppli charges no surrender fees. Ppli is significantly more flexible, as you'll hear in a moment, and Ppli has more tax-efficient investment options than does a retail policy. At death, that benefit can pass income and estate tax-free to the beneficiary. And as a security, there are some, full disclosure, as a security, there are some legal costs to set up such a plan, but the costs are well worth it for the right individual. Most of the stuff that I've spoken about today can be looked at in a book that I was privileged to co-author for the American Bar Association, The Advisor and Trustee's Guide to Managing Risk. As Barry mentioned a little while ago, there are some handouts. I think it would be a good idea to take a look at them. And as far as my information is concerned, if anyone has any questions, obviously, please feel free to give a call or an email, and I'll be more than happy to entertain and answer any questions that you might have. With that, it's my pleasure to turn the floor over to my colleague, Steve Horowitz. Steve, it's all yours.
Thank you, Henry. I think that was very informative even for me. I enjoyed it a lot.
Thank you.
I'm going to take the next little bit of time and explain a type of life insurance, which is essentially, it's labeled as private placement life insurance in the United States, by and large, because of the fact that due to the securities issues that Henry was mentioning before, as a matter of law, it is generally sold with an accompanying private placement memorandum. In other parts of the world, it is purely called life insurance as a simple matter. Essentially, the way that a private placement life insurance policy works is the same as the variable universal life chassis and product that Henry was speaking about in his presentation, that many people are familiar with. And over the last 45 years, I would say, probably in the late 1970s was when universal life started. The mid 1980s to late 1980s, as the stock market was performing very well, was when the variable universal life product started. Because as the stock market was growing, the life insurance carriers were realizing that it was more difficult for them to make money based upon what they really make money on, which is, believe it or not the sale of life insurance and the payment out of death claims. The large preponderance of most insurance companies' money that is made from the management of money. And during the time period when, if those of you who are old enough to remember the Carter administration, when interest rates were into the 20% range for money market and mutual funds, and certainly even plain old money market mutual funds, they were, and prime rate was, the prime interest rate was about 24%. People were taking their existing life insurance policies and borrowing money at their 5 or 6% loan rate and reinvesting the money somewhere else and realizing the arbitrage. Now, with only the interest rate to be charged and for them to earn, the insurance companies decided that they needed a way to compete. So part of what they did was that they unbundled the box. They took regular life insurance and they decided that they were going to make the universal life chassis, which would provide a greater degree of rate of return and an unbundling of the combination of what was in the black box of a whole life policy, and make it available to be seen that you could have a choice of investments. You could have, certain types of interest sensitive investments, so that they could provide you with a greater yield, and therefore you would no longer be hollowing out your policy, borrowing it down to a minimum level, eventually potentially risking lapse, and because there were many people who didn't pay the interest rate, and then they wound up with taxable gain on these lapsed policies. More importantly, for the insurers, it gave them the ability to participate in the fees and charges and costs of the mutual funds. The one requirement was that the only thing that they could have at the time was a clone fund. And you can change to the next slide. Thank you. Okay, so what makes private placement life insurance, as it's referred to here, different than the variable universal life, which was designed in the mid-1990s through the early 2000s, which were basically the wrapping of mutual funds inside of life insurance policies, which were done via clone funds. The objective of the private placement life insurance contract was to wrap what are normally tax inefficient investments or taxable investments into a uniquely designed life insurance vehicle, which we tried to structure as a non-modified endowment contract, or non-MEC, as that term is defined in Code Section 7702 capital A. And we try to make sure that we have a policy which can then be borrowed against, because among the major benefits, as Henry was talking about earlier, of life insurance contracts is the ability to borrow out cash over the life of the individual on whose life the policy is taken out. The further benefit is that when someone does the borrowing and takes, let's say that we have a policy that has $1 million cash go into it every year for 2 or 3 or 4 years, so that it becomes a non-MEC, and the pardon the noise behind me, and the growth of the policy is to $7, $8, $9 million over a period of time, and then the individual decides they're going to take out a loan every year for 10 years of $400,000. So they've now got $400,000 worth of loan. The borrowing is at a very efficient, extremely low, non-traditional U.S. policy rate when you're dealing with private placement life insurance. But now let's say that the $10 million worth of total assets that's in the policy, or $11 million, I think in my example, let's say that minus the $4 million worth of loan, and the individual dies. When the individual dies, the death benefit and the loan are netted against each other. So the cash value may have been $11 million, the loan may have been $4 million, and the amount of life insurance wrapped around that may have been an additional $10 million. So their family is now going to get $17 million income tax-free, and the $4 million of loan that was taken out is going to wind up in a position where it just evaporates. There is no tax paid on that money that's been previously borrowed, because that's one of the benefits of life insurance. We can have contributions, as it says here, made one time or annually at the discretion of the owner. Normally, to make a non-MEC contract, we design it so that it's paid over at least 2 or more years, but there are actually ways to design a non-modified endowment contract policy in a manner where it requires only one-time funding. Basically, the most, the characteristics accomplished by a non-modified endowment contract is really simple. Tax-free investment growth, tax-free access to the dollars that are in the policy by either one of 2 mechanisms. One is borrowing, and the other is via a surrender up to basis. The investments that are made inside of the policy grow tax-free and are all based upon the both future contributions on ultimately, and the underlying performance on the investments. Most of the contracts that you'll see done as private placement variable universal life contracts are done in a manner where there is largely reliance on the underlying investment gains and the performance of either the hedge funds, mutual funds, closely held business interests, private equity interests, et cetera, because the major benefit of private placement life insurance as it's sold today is that it can be done in a customized or bespoke fashion. The death benefits associated with the policy are going to be received the same way that any other death benefit of a policy is received under the Internal Revenue Code, and that is under Section 101, assuming that all the conditions are met and there's been no transfer for value, they are going to be received income tax free. However, if they are owned by the individual, they would be received subject to estate tax under the applicable sections of the Internal Revenue Code, namely Section 2042. The more important, so from that standpoint, from an estate planning standpoint, it's really very important that the design, establishment, et cetera, be done so that there is a trust which is deemed or which is established as the owner of the policy for estate tax purposes and for estate planning purposes, which will give us the benefit of both income tax free payment of the death benefit and estate tax free payment of the death benefit to the beneficiaries of the individual insured. Someone can select in the design of the policy, they can either select option A or option B, which, and there's a typo there, I apologize, it should be capital A or capital B, which are basically life insurance terms which say we either have the cash value add to the death benefit or the cash value not add to the death benefit. It just lowers the overall net amount of risk over time. From the standpoint of most private placement policies, it is done as an option B contract, where the value of the death benefit is going to grow based upon the cash accumulation, because the people who do these kinds of policies are expecting that they will have either private equity-like gains, they'll have hedge fund-like gains, they'll have something that is, far more lofty than the traditional life insurance policy payout done through most commonly either universal life or even traditional variable universal life, if you can find traditional variable universal life with different locally known fund flavors, I would say, as the various investment options. So please, Barry, please move us on to the next slide. Okay, essentially the way that a private placement policy is done is similar for those of you who are familiar with funding a regular life insurance trust. The individual contributes cash into the trust. The trust then buys the private placement policy by contributing cash to the policy. The policy has an IDF manager selected who will make the investments. This is the one major area where there is a difference between private placement life insurance, and there are two major areas, but the single most significant area is that the individual themselves, who is the owner of the policy, is not permitted to make or control the investments in the private placement life insurance policy. There is a doctrine called the investor control doctrine, which I'll discuss a little bit later, which causes there to be the need for either an asset allocator investment advisor who will make all the investment decisions, or nowadays, more commonly, you'll find that under Treasury Regulation Section 1.817-5F3, there is a requirement that there be an insurance-only policy, so that you have to have an insurance-dedicated fund inside of the policy construct, which you see laid out in one of the next slides, but we won't go there yet. That manager who is selected makes the investment decisions. Now, some of the people that we deal with, they invest on their own, and they also have whoever their IDF manager is get a copy of whatever investment opportunity offerings, et cetera, are going to go to them. A copy of it will also go to the IDF manager, and they will make it, and the IDF manager will do their due diligence and make the decision about whether or not to buy the assets that have been selected. Likewise, these shares are then sold as a result of that decision to the policy, and the cash that's been funded into the policy is then funded over into the is funded via the purchase of the shares of the company. So basically, the owner selects a discretionary IDF manager, which the owner does have the right to change at some point over time. The investment gains that are going to happen, let's say that somebody bought shares in a private equity fund, and the private equity fund had one company that monetized at a 10 times or a 10x rate of growth, and at that point, the policy now has cash of a substantial amount. Just like with regular life insurance policies, like Henry was describing, the investment gains are not taxed, and it increases the cash value that's inside the policy. So get the benefit of the tax-free growth. Then, as you see, number 5, the cash value can be borrowed or withdrawn tax-free, and the loans are at a very low interest rate. When the individual passes away, the death benefit amount, the insurance that's required that surrounds the policy cash value, which is also commonly referred to in the insurance world as the cash value corridor, or net amount at risk, is going to be the combination of, as I said in the example earlier, amount contributed, growth on the policy assets, and the death benefit corridor that's required to surround it. All of those things are received income tax free, including the investment value plus the insurance, net of whatever loans have been borrowed, and if properly structured with a life insurance trust, subject to 0 estate tax. Please pass the slide. So it has, as you can see, private placement life insurance has a variety of tax efficiencies. You have tax deferred growth on investments, including capital gains, dividends, and interest. There's no tax today, no tax on the compounding of the investments. Assets can be borrowed against for any purpose. Tax-free withdrawals on the total value, including the growth surrender up to basis or loan, as I described before. There's no early termination or withdrawal penalties, as there are with either retirement plans or annuities. And there's no income ineligibility as compared to a Roth IRA. And there are no contribution limits, provided that someone can find sufficient life insurance capacity to provide for an adequate amount of corridor or net amount at risk. At the end of day, assuming that there are in-kind assets, when I say the end of days, I don't mean the end of the world. I'm referring to the end of the individual insured's lifetime. Assuming that there are certain types of assets that are inside of the policy that are permitted to be distributed in kind, and certain jurisdictions provide for the distribution in kind of those assets will receive a step up in basis equal to fair market value at the date of death of the owner of the policy, or the date of death, in this case, of the insured, because the owner of the policy will likely be a trust. Sometimes we do have policies that are owned by the individual because they don't have any concern for the estate tax. I don't, as an estate planning attorney, primarily over time, to me, that's not something that makes sense, but it is a feasible option for someone to own the policy themselves. And you can change the slide. The requirements of PPLI, there's a participating insurance company which purchases reinsurance. It's normally in the form of some kind of annual renewable term or institutional insurance from a major reinsurance company like Zurich or Swiss Reinsurance, Munich Re, Arch Re, Gen Re, etc. A couple of which are companies owned by Warren Buffett, but I guess he's the insurer of last resort of many places. We can also, in the alternative, utilize some kind of bolt-on strategy where, rather than just having traditional reinsurance, we may utilize a premium financing funding concept to go to a bank utilizing the assets as collateral and have a bond financing which might wrap around and pay the premium on additional insurance, not to buy reinsurance from a major reinsurer, because there is a crossover point in either the term world or the institutional reinsurance world where the costs of insurance over a relevant range, there's a crossover point where the costs become exponentially more exorbitant as you reach towards normal mortality. So just for example, when someone is 50 and takes out a policy, and it's an annual renewable term policy, the policy may cost $1,000. By the time they get to age 80 for, let's say, $100,000 policy may cost $35,000. By the time they get to age 90, the policy may cost $100,000. And by the time they get to age 95, the policy may cost $110,000 per year, at which point, as Henry said before, these policies will never pay off. Because of the, first of all, these institutional term policies don't lapse, but no one would want to keep them because they cost too much. And that's part of the, if one was to actually do an examination of life insurance, one of the things that Henry spoke about was, the fact that, what should have been a front page article about the mispricing of life insurance and the lapsing wasn't, because one of the things that exists in many states is something that's called lapse supported pricing. And that is that the overall cost of a pool of insurance is made to be less based upon the fact that they not only rely on investment yield, they rely on the fact that many policies will never reach payout. And one of the things that I actually found very informative about Henry's discussion was that, term policies, of the term policies taken out over time, only 2% of them ever result in a death benefit claim, which is, pretty much unfathomable when you think about it. And now you know why the insurance companies don't necessarily mind there being lapses, as long as it's reached a crossover point where they've already made back their money. And this is not in any way, shape, or form meant to be anything that bashes the insurance industry, because they're very near and dear to every estate planner's heart, because it's something that we use both to, as Henry said, to replace income. We use it to replace the wages of the individual who is the primary breadwinner. We use it to pay transfer taxes. And nowadays we use it even to pay long-term care insurance costs, which have grown to be prohibitive for many people. And the Pension Protection Act did America a very big service by allowing for that utilization. So we have another, as I said, there are two major requirements in any private placement policy. And one of those major requirements was the investor control doctrine, which we'll discuss a little bit more length in a couple of minutes. The other is that there is a requirement for the diversification of a portfolio of assets. In 1984, as part of the Deficit Reduction Act, there was part of Section 817 that was enacted, said that in order to have a properly designed private placement policy, you had to have at least 5 investments. And the reason I say that you have to have at least 5 investments is that no one investment asset can make up more than 55% of the insurance sub-account portfolio. No 2 investments taken together can make up more than 70% of the portfolio. No 3 investments together can constitute more than 80% of the portfolio. And no 4 investments taken together can constitute more than 90% of the total assets of the account. As a result, it doesn't take a rocket scientist to figure out that we must have at least 5 investment assets in the portfolio in order to qualify as life insurance under the variable universal life standards of Section 817. And one thing to mention as a cautionary note in this situation is that series of stock issued by an institution is that if it is issued by the same issuer, so for example, you had IBM class A, B, C, and D, those would all be considered one investment for purposes of the diversification rules. If you had one piece of land and it was called Blackacre, you would not be in a position to take 1/5 of Blackacre and break it into, you would not be able to take 20% of Blackacre and put each 20% into 5 different LLCs and say you had 5 different investments. With that said, there is a requirement that the diversified portfolio be built over a 12-month period. So you have 1 year to essentially build the diversified portfolio and a 13th month to cure if there is a defect to bring you into balance. If, however, the assets are largely comprised of real estate and you have a real estate investment type of fund that is going to be your private placement net, the basis for your private placement policy, you have 5 years within which to diversify, because someone obviously took into consideration the fact that real estate was not as readily liquefiable or diversifiable if you had one investment. So they gave you a test at the end of 4 years. If you could prove that 80% of the policy was made up of real estate, you would have 5 years within which to diversify. So you could have one single investment that lasted the 5 years before you were required to sell it. You can switch to the next slide.
CLE code P-L-248, P-L-248.
Okay, so as far as the investor control guidelines are concerned, there are a variety of rulings that the service has published. There are a variety of private letter rulings that came up over time. There was a ruling in 2001 dealing with hedge fund life insurance. There was a PLR. There was two revenue rulings in 2003, 91 and 2003-92, which essentially said that certain types of hedge fund investments were not to be allowed because they were publicly available. Believing that the Internal Revenue Service didn't have the right to make that decision that it was publicly available, and that you would be able to look through for the diversification purposes, they made a decision later on that there was going to be an elimination of something that had been around before, which was a look-through rule that allowed for a small partnership like a hedge fund, a small unregistered partnership like a hedge fund, to look through to the underlying investments, which most hedge funds that are out there, trade, millions of trades a day, if not a week, if not, and in those days, if not a year. So you had more than a diversification of the basket of investments. They said that you could not look through to those investments because they were publicly available. Most hedge funds, if you have an investment that is available to only people who are qualified purchasers, which means they have to have $5 million worth of liquid assets in order to actually be considered to purchase the policy. I don't think that those should be considered publicly available, but rather than argue, which some people were doing at the time, the service then repealed that small partnership exemption, and that's when the requirement for insurance dedicated funds, which had meaning only insurance companies, policies of insurance companies' own treasury accounts could be the investors in the policy. They repealed that small partnership exemption and renumbered the regulations under 1.817-5F. As far as the guidelines for investor control, probably the most significant development that you'll find is a case called Commissioner versus Jeffrey Weber, which was decided in 2015, June 30th, 2015. The tax court, Judge Lauber, held that a policy in which an individual had taken out 2 policies on his elderly aunts and had them invested in 43 to 45 different investments, all of which were companies on which he was a venture capitalist, and all of them were companies which he funded in 4 different sources. Esther, stop. From 4 different sources, not the least of which was he directed through his lawyer, he directed the IDF manager, which was a bank it was called Bank Butterfield in the Caribbean, very well known to anybody who's ever visited a Caribbean island. They were paid a very small fee and communicated with, between the lawyer communicated with the client about 1,700 times, and the lawyer then communicated to the accountant and the IDF manager about 75,000 times through email. We won't even go into how many times they talked on the telephone. In any event, the decision in that particular case, while stating that it was violative of the investor control doctrine, and while eliminating not dealing with the issue of whether or not a grantor trust or a non-grantor trust was relevant, even though this individual wasn't the policy owner, he was definitely deemed to be in control based upon the fact that he dictated every investment, and 41 of the 43 recommendations that he made were taken. And as a result, we know that the facts of Weber, which are very well spelled out in an article that I that I wrote that's available in the Journal of Taxation of Investments in 2017 speaks to the issue of untangling the tangled web of Jeffrey Weber. As far as the particular case itself, it provided a lot of guidance that was very valuable because it created some level of understanding of what was abusive. Where there is a middle point of dealing with what is abusive, there is no safe harbor. There are no other rulings that particularly deal with what is or is not permissible in terms of that degree of investor control. I can tell you, however, that case did make very clear that what was determinable was not whether or not someone was an owner or on the board of directors or was a co-shareholder in another capacity. What was determinable and dispositive was whether or not the issue of what was to be owned by, purchased in, or sold by the policy was held by the manager who was deemed to be an agent of the insurance carrier, or whether it was the control party, namely either the funder of the policy or the trustee of the trust or the actual policy owner or the insured. Those are people who cannot exercise control. And I think my time is just about up. So I think I'll turn it over to Mark.
I just want to add what's significant about, to me, what Steve does is you're involved in the actual design. It's
That's
one
correct.
thing.
We
We
design them from soup to nuts, and then we make sure that they are monitored to be compliant.
That was the second word, compliant. Thank you.
So we're going to change gears a little bit. We're going to talk about spousal lifetime access trusts and spousal lifetime access non-grantor trusts. But SLATs are a very, very popular and common estate planning tool. And the insurance planning that's been talked about often should integrate with the trust planning we're talking about. I'll give you an example or two. If clients have transferred substantial wealth to spousal lifetime access trusts, they need to evaluate very carefully, and frankly, it should be done as part of the same plan, how much long-term care coverage, how much disability insurance, how much life insurance they have, and the insurance planning should complement and supplement and protect the SLAT planning. Now, why is this so relevant and important for all of you? If you, and I forgive me, but I'm trying to speak to a fairly broad audience in the sense that I know you're all attorneys, but I was told that some of you are estate planning specialists, so that I need to be relevant to you, but that many of you are not, and everything in between. So in the short time we have, it's hard to take a topic and cover it in such a broad way, but I'm going to do my best to do so. So if you're practicing as an estate planner, the insurance conversations that we just had are absolutely critical to the planning you've done. And why is this so important to so many people that do estate planning? Even more general practice attorneys were getting pulled into estate planning, because in 2020 and 2021, and to my surprise, even in the beginning of 2022, clients with great zealousness were rushing, pushing, trying to get planning done out of concern that the many different proposals various Democrats had proposed in Washington, and I'm not being political, I'm speaking solely as a tax attorney, could have been enacted. And those proposals would have made dramatic, harsh changes to the entire estate tax system. So clients were rushing to get planning done. And for married clients, spousal lifetime access trusts were almost the default plan. Why? Because I can set up a trust for my wife. She can set up a somewhat different trust for me. And I'm a beneficiary of her trust. She's a beneficiary in my trust. And theoretically, we have access to 100 cents of every dollar that we transferred out of our names, but yet it's out of our estate. So that kind of planning for married couples was really almost a default or go-to type plan. Yet because of the pressure of getting the planning done, many of the things that the prior speakers spoke about, especially Henry's comments about insurance, were just really not addressed. So it really behooves all of us to circle back and address that. Another point, for those that practice in estate planning even a little, a spousal lifetime access trust is honestly just a more robust version of the somewhat traditional, very well-known common ILIT, irrevocable life insurance trust. So the insurance trust that many, even general practitioners, have done for decades, a spousal lifetime access trust is really very similar. Not uncommon for one spouse to create a trust to own insurance on their life to benefit the other spouse, and if there's children, the children, and further descendants, if applicable or appropriate. Now, another thing that's really important for 100% of the people on the call, even if you're not an estate planning specialist, is that spousal lifetime access trusts, if you're married, are an incredibly important tool for us as practitioners, we as practitioners, to look at for our own planning. And in far too many cases, we are the proverbial barefoot shoemaker. And in fact, Henry and I just penned an article talking about that very point, because so often we as attorneys are so focused, and it's a compliment to us, we're so focused on our clients that sometimes we neglect ourselves. And we really have to take time. I'll use, I think it was Stephen Covey's concept of sharpening the saw. We have to take time, even though we're so busy taking care of clients, to protect ourselves. There's malpractice risks are very significant. If you're part of a firm, or even if you're a solo practitioner, you may have personal liability on a large lease and so on and so forth. Protecting our assets should really be important. So this topic is not only very relevant and ties in significant ways with the prior discussions, it's not only relevant for estate planning specialists, but for every attorney that practices. So in the time that we have, I want to talk about some different aspects of administration of these trusts and things we should do. But again, I apologize for belaboring it, but I just feel it is so very important that before I get into the slides and end up running out of time, I want to talk a little further about the tie-in and the relevance of primarily Henry's discussions on insurance and these spousal lifetime access trusts. But before I do, and I keep meaning to do this, so forgive me. If you're a single individual watching this as an attorney, or you have clients that are single individuals, it's not that I'm not trying to be conscious of planning for single individuals. You would use a variation of this kind of planning, a domestic asset protection trust, or DAPT, in which you're named as a beneficiary of your own trust, or a special power of appointment trust. And by the way, SLATs, even though most people translate spousal lifetime access trust as the definition or the explanation of the acronym, there's nothing that means that it has to be a spouse. It could be a sibling. It could be anybody that you're close with, where you set up trusts that are not identical, but to benefit you and this other person. So I'm not going to be able to go through all that. There's just not enough time. So I just wanted to make sure that was out there so nobody feels that I was only focusing on married couples, but I just have to narrow the topic to be able to do it. But many of these concepts could be applied in the context of planning for single individuals. It's just, there are some differences. Now, one of the reasons that I think it's so important to get an insurance consultant to look at the planning that so many of us did in 2020 and 2021, and if you're doing your own planning, you should do this, is because, let me give an example. Let's say somebody's worth $10 million. And they want to transfer $5 million to a trust to use up some of the exemption. And as many of you are aware, and if not, you all should be aware, in 2026, barring another change in the law, the exemption is cut in half. So it's going to drop from the current 12 million and change to 6.5 million, depending on the inflation adjustments, which based on inflation now may be bigger than what we thought 6 months ago. So many people will continue and should continue to do this planning. Leave aside whether the example I gave you is appropriate in terms of how much exemption is used. Let's just focus on the relevance of insurance. Many people in the past few years have, and many people before 2026 will, try to use up their exemption, setting up spousal lifetime access trusts. A typical SLAT may be My wife and I each set up these trusts. When I do them, by the way, I put them in different jurisdictions to differentiate them for the reciprocal trust doctrine. My slat's in Alaska, my wife's is in Nevada. But if people are worth, for example, $20 million, and each spouse put in $6 million, and I'm not suggesting that's an optimal plan, I'm just trying to illustrate a point. Collectively, the two spouses have given away 12 of $20 million, more than half of their net worth. That's a very substantial portion of their wealth. Now, in 2020 and 2021, I saw a lot of people giving away larger percentages of their wealth. But what should have been done, and I recommend it to all of my clients, and I encourage you that if you have done this kind of planning, to go back to clients that did it and recommend this. And if you're going to do the planning, or you do new planning for new clients before 2026 when the exemption drops, recommend they get an insurance evaluation. It's not only really helpful and protective for the client, it's protective to us as practitioners. Why? Because if an insurance consultant comes in and says, okay, Mr. and Mrs. Smith, in my example, where each of them are putting in $6 million into non-reciprocal spousal lifetime access trusts, let's evaluate your ability to pay for long-term care costs. Right now, you have no insurance, but you're giving away, call it 60% for argument's sake of your net worth. Now, all of a sudden, you have even a greater need for the coverage. Now, whether the client buys it or not, the fact that you're helping them get somebody to evaluate this and show them what the numbers looks like is a very big service to the client. If they also consider premature death, mortality risk. So if I set up a slat for my wife and she dies next year, I lose indirect access. And yes, there's ways to draft around it, but I'm trying to focus on the insurance element. If I lose indirect access to the slat I created for her because she's the beneficiary, I'm not, now she's passed away. If I simply bought an insurance policy on her life, which may be held by her slat, because remember I said earlier, slats are just very robust insurance trusts, I've now insured against the risk of premature death. So if you have an insurance consultant, go back to all the clients that did this planning and evaluate long-term care coverage, life insurance for the reasons I said. And I would throw disability coverage in for many clients, not all. If clients are in their 50s or 40s and did this kind of planning, and we all had young clients do this because they were just as concerned about the estate tax changes, which were very harsh, then they may need disability coverage where they may not have needed it before. Why? Because if they just shifted 60% of their wealth into irrevocable trusts, it may make sense to get coverage where they didn't have it. Now, something inherent in what I just said was contradictory, but it's really not. I think it's just conservative planning, and let me explain. I've suggested at several points that insurance evaluation is important to protect the clients, but I also said that when you set up these non-reciprocal slats, I'm a beneficiary of my wife's trust, she's a beneficiary of my trust, so long as we stay married and we're both alive, which is hopefully the case for a long time, we both benefit fully from the assets if we need to in the trust. Why do you need to insure against the risk of premature death, disability, or long-term care costs? I think it's partly a balancing act. I think it makes sense to look at the coverage. If the analysis shows that a couple $1 million term policy for 20 years is all that's necessary, even 10 years, to make sure that if there's a premature death, that the surviving spouse will not have inadequate resources. It may be an inexpensive fix. Why not fix it, even if you can get access to one of the trusts? And even if there's other ways to get access to the trust you created. So I think, they're all factors to be considered. How does this protect you as a practitioner from malpractice? There was a case in California, and forgive me, I just don't remember the name, and I don't know that I even wrote it down, and I don't know the current resolution. It may have just been settled because I don't recall hearing any follow-up, where a client did a trust plan in 2012 when, similar to now, they thought the exemption was going to go down. And the plan was so successful, client should have been thrilled. But what happened? Client sued the attorney because she didn't have adequate resources to live on because of the tax cost, income tax cost each year from the trust. And the claim made, which I think is really inappropriate, unless there's extenuating circumstances, that the attorney should have done a financial analysis, projections and forecasts to show the impact of the plan on the client. And I think that's kind of inappropriate because few attorneys have the wherewithal to really do financial forecasting. And that's really something that should be done by a financial insurance, wealth management type professional. So that's some background, and that's how it ties together with the program. One last point, and I know I'm using up a good bit of the time on this, but I think these are really important points. And this, I think, is the most important point, and it goes back to my barefoot shoemaker comment. We all live in a very litigious society. Malpractice claims against attorneys, especially in the estate planning arena, have grown significantly and are very worrisome. And there have been a number of very notable, large, worrisome malpractice cases against estate planning attorneys. And I don't think that's going to get better. I frankly fear it's going to get worse as time goes on. What does this have to do with our topic of slats? If you're married, and if not, again, DAPs and SPATs and other techniques beyond our discussion today could be used. But if you're married and practicing as an attorney, do you have irrevocable trust that you've created to protect and safeguard your assets? If not, you should. This is not just planning for clients. This is really fundamental planning for us as attorneys to protect ourselves. And when I spoke about my wife and I having slats, we have non-reciprocal slats. Mine's in Alaska, hers is in Nevada. I take my own medicine because I very much believe it works. And the sooner you get that kind of planning set up, the earlier and well in advance of any kind of claim you get assets transferred, all the better, right? So give some thought to that for yourselves. Now, one of the issues to be mindful of if you engage in this planning, and some of these slides I'm going to go through more quickly because I think the points that I just spent up until now talking about are very important, and I want to just focus on highlights of the more important things. Now, if you have done clients have done planning over the last year or two, there may be ways to unravel the planning, and that's important to think about. If the client doesn't want the planning because the law didn't change, and that may be a mistake because the exemption is still being cut by half, there may be ways to unravel a plan. You should advise clients that they need to come in and look at the planning with you to see if that's going to be the case. We just had in the past week or two, rather not as harsh as we had thought, but still pretty harsh proposed regulations issued on clawback. So some of the planning that our clients have done over the past few years to safeguard exemption, like busted preferred partnerships, Q-tip renunciations under 2519, grits that had zero value associated with the retained interest. And if those concepts are behind you, just get the big picture because we don't have time to go into them. All those things are not going to work to safeguard exemption. So it's very important to review with clients unraveling planning. Q-tip trust, very important to speak to the accountants if they're preparing the gift tax return, or for you to meet with your clients before preparing a gift tax return if you're doing it. A common planning tool, because we had no clue what the law was going to be. Some clients may have made transfers to a trust that qualified for the marital deduction. And then that gives them sort of a look back. So if they did this in 2021, they have until a gift tax return is filed, which could be as late as October of this year, to decide whether or not to elect the marital deduction. If they want the gift complete so that the trust is actually funded and uses exemption, then they don't make a marital deduction election. If they don't want to use their exemption, then they do. So these kind of things need to be followed up with clients. Another important point on administration of many types of trust, not just slats, is defined value clauses. And again, it's complicated, but let me just define it for those that aren't familiar, and let me point out some of the issues even for those who are familiar, because I see way too many mistakes with this all the time, and it's worrisome. Here's what a defined value mechanism is. If I sell a $10 million asset to my trust, I could say I'm selling 50% of the ABC Family Holding LLC to the trust. But if I sell 50 percentage interest points, membership interest, the LLC, if the IRS comes back and say, Marty, your appraisal is wrong, the real estate's worth a lot more that's held in the LLC. It's not 10 million what you sold, it's really worth 20 million. I now have a $10 million potentially taxable gift. Bad result. So we use a valuation adjustment mechanism where I sell 10 million worth of the LLC interest, not a fixed percentage. Here's the administration point that's really critical to follow up on. And I see mistakes happening with this constantly. So it's very important if you do this kind of planning to get after your clients. That treatment that you gave or sold in my hypothetical, 10 million, not 50%, has to be treated uniformly in all aspects. What do I mean? If you have a trust, you have a trustee. What's the trustee reporting on their books and records? Too often, even institutional trustees book it wrong because they have a clerk input in this data, and the statement says every month that there's a 50% interest in the LLC, not a $10 million interest. That's wrong, and it contradicts the tax position. Did the accountant preparing the gift and income tax returns understand this? Is there a supplemental schedule attached to Form K-1? Does the gift tax disclosure seem properly done? If there's a personal or trust financial statement or entity ownership list, is it listed properly? In so many cases, it's not. So that's very important to take a look at. And some of the more complex ones, like Christensen-Petter type waterfall defined value mechanisms, it's just as important that it be done right. So that's a very critical point to follow up on. Now, what did the Nelson case do? People use these types of valuation adjustment mechanisms, but they did it inartfully and they got creative in their writing. You don't want to, this is not a creative writing class 101. If you're using a defined value mechanism, it has to clearly specify that the adjustment will be based on gift tax value is finally determined. And if you've done this and you got creative or different with any of the language you use, go back and revisit it now. I don't know that you can retroactively fix it, but boy, if I saw a mistake like this, I would try to, because at least it gives you an argument. Let's skip some of these and go on. Now, very common in all types of trusts. And when you're dealing with the types of trusts that own the complex insurance interests and significant or valuable insurance interests and rights that were talked about earlier by the two other speakers, it's very common and makes a world of sense to use trust protectors or directors in the instruments. You have to be very careful because the language is very imprecise. Lots of attorneys, so if you inherit a trust from another attorney that prior counsel did, you got to figure out exactly what they've done. Don't rely on the use of the language that they have, because so often it's imprecise and different people will call things by different names. Is the protector operating in a fiduciary and non-fiduciary capacity? What does the trust instrument say? What does state law say? And if you're advising somebody in that role, that distinction between fiduciary and not critically important. What I find in too many cases where others have prepared the trust and named a protector, they don't even have the protector sign the trust document. We at least have them sign a counterpart if we can't get them at the meeting where the trust is signed. They have to me, I think it's prudent to have them sign the trust or a counterpart. It shows they have the trust document. They should have awareness of what they're doing because they've been given the trust and they've agreed to assume the role. The other point is when you have annual review meetings, which are critical for complex trusts, the trust protector should be involved. Be careful to delineate who you're representing. Now, trust protectors are often given a wide range of different powers. It can vary dramatically depending on state law, depending on what's in the instrument, so on and so forth. But if you have a trust protector that has powers to correct scrivener errors, make administrative changes, decant the trust, change situs in governing law, it's different than what we've all lived with for the vast majority of our careers. What do I mean? We've all in the past, when we did an irrevocable trust, we would say it's carved in stone. Trusts are not carved in stone with decanting. And New York has, by the way, a very robust decanting statute. So if there's the ability to decant, if you have a trust protector that has rights and powers to change trustees, you can't just sort of rest on what the acronym that we used in accounting was SALY, SALY, same as last year. So if you have a trust that's paying high New York state and city income tax, and all this trust has is a securities portfolio, and it's a non-grantor or complex trust, the trust protector may be able to fire the trustee, hire a new trustee in Delaware, where there's no income tax if there's no Delaware beneficiaries, move the trust and save all the New York income tax every year unless there's a distribution. We need to be alert to the more robust, flexible. It's a good thing, but it's also a riskier thing because it means we have more responsibility. What a trust protector can do to change powers. Some trusts include, and these will be grantor trusts for income tax purposes, the power to add charitable beneficiaries. Has it been done? Has somebody looked at it? Is there a benefit to doing it? Does that power continue after death, even when it can't serve to characterize the trust as a grantor trust? Is there a reason to add a charitable beneficiary? If the trust is paying high New York City and state income tax, maybe it's an advantage to add charitable beneficiaries when it becomes non-grantor. Loan provisions are commonly included in trust. It makes the trust, if it's done in the way I'm going to describe, a grantor trust for income tax purposes. In other words, if I set up a trust like I did my SLAT for my wife and descendants, and I gave my friend Joe the ability to loan me money out of the trust without adequate consideration, whatever that means, that makes the trust a grantor trust. But in recent years, I've used loan powers in a much more robust way. As I described earlier, clients have been putting greater percentages of their wealth into trust, and you as an attorney may want to put a substantial percentage of your non-pension, non-retirement asset wealth into a trust to protect it from claims of malpractice. Giving somebody the right to make you a loan out of the trust assets without adequate security is a wonderful way to give yet another way you can access the money in the trust. I don't care if I die owing my trust money. I want to make sure I have money to eat when I get old and gray. I guess I'm already gray. So the loan provision could be quite important. Clients misapply this all the time. Try to educate your clients, especially if you can get them to come back. And if not, consider, a mailing to clients on trust administration for all the trusts you've created. They have to call you before they do a loan. If it's a loan to the settlor of the trust and it's a non-grantor trust, meaning the trust pays its own income tax, that loan could blow the whole intended tax status of the trust. That's a problem. I've seen people make loans without any kind of documentation. How's it a loan if there's not a signed legal note, binding note document? As attorneys, whether you do any estate planning or not, if you do a loan, you got to have a loan document. Get clients educated that they have to follow up with you. And this is just yet another illustration of the myriad different aspects of what we need to do to properly administer loans. And here's a sample provision, and here's some more on it. Decanting, where you can merge a trust into a new trust. You can change, restructure so many aspects of a trust. A lot of the things that, not so many years ago, we were just, we're stuck with this client. We can't, not that we're stuck with the client's stuck with those provisions of the trust, but with the ability to decant or merge the trust into new trust, you can rewrite all the administrative provisions. It gets a little dicier when you start tinkering with, and you may not be able to, beneficiaries, but there's incredible flexibility to add powers of appointment, change administrative provisions, change the tax results of the trust, shore up the intended tax results of the trust. So very important to get clients back with irrevocable trusts. I think Henry used, I'm trying to think of the term, buy and hold or something when talking about a life insurance policy in the context that clients mistakenly, terribly mistakenly, think you can buy an insurance policy and sit on it. Clients are even worse when it comes to a trust. They'll set up a trust and think, oh, I set up a trust, it's done, it's irrevocable, I can never change it. Absolutely not. We need to get them back and review the administration of the trust and all the options that decanting and trust protectors and other modern trust drafting provisions give us, because we can always enhance the results over time. Swap or substitution powers. This is the power that has been used pretty much as the default to assure that a trust is a grantor trust for income tax purposes. That means, for those that aren't familiar, I pay the income tax on the income my trust earns, but the money stays in the trust. What a great way to enhance asset protection, shift more wealth out of my estate into the trust. But that swap power, if it's going to be used, has to be done properly. And too often it's not. Frankly, too often I don't even know that clients have done it until I hear after the fact that they did it, when we find out, when we finally get their attention. We need to try to all educate our clients that they really need to talk to us about this stuff. I've had financial advisors advising clients about the legal nature of a swap many times because they think it's routine. actually, it's not necessarily routine. You have to read the terms of the trust, which is obvious to everyone on this call, but not necessarily to a financial advisor. And if it's an irrevocable trust and it's got specified terms and requirements to do a swap of assets between the person setting it up and the trust, you got to make sure you adhere to those. If there's a non-marketable asset, I put into my SLAT interest in a family business. Well, now the business has changed. The trust was benefiting my son primarily, and now he's become a bum, and my daughter's running the business wonderfully for years. I want to get the business out of the trust that's going to benefit my son because he doesn't deserve it. He's not in the business. I can put in cash, pull out the business, and then put it into a new plan to benefit my daughter who's running it. That's all fine. But in most cases, because the business interest is non-marketable, you're going to have a formal appraisal and make sure it's comparable to the value of what cash you're putting in. So there's a bunch of stuff on swap powers to help you. Am I out of time? I think we're supposed to stop at the top of the hour.
I've left a few moments for perhaps yourself and Steve to speak out from a legislative point of view, from President Biden's playbook, Green Book. Any thoughts that either of you might have in terms of
the Green
to our audience?
I can give you a quick comment on the Green Book. The Green Book has lots of the harsh tax planning that never made it through Congress in 2020 and 21. So what does it mean? First, it means that the potential for really strict adverse tax change is not gone. So clients should still plan, and everyone on this call should still plan and protect your assets while you can, because you don't know what may happen tomorrow. And trying to predict politics, forgive the analogy, it's worse than predicting the weather, right? I just like having an umbrella in the back of my car because I don't trust the weather, man. You can't predict what Congress may or may not enact. I think it's pretty unlikely that any kind of tax legislation is going to go through. But now that I've said that, maybe it will get passed tomorrow. I don't know.
And
Second
Steve,
point.
I'm sorry, Marty.
Congress was Biden's administration was very strategic in the changes they did make. And they kind of dealt with a lot of the things that prevented the tax legislation from going through, some in very creative and different ways. So don't count it out, even though it seems unlikely, that stuff may pass. So again, if you haven't done your own asset protection planning and SLATs or DAPs make sense for you, go for it. If clients are still sitting on a fence, get them off the fence. And hey, by the way, the exemption's getting cut by half in 2026. Everybody should plan.
Thank you. Steve, you've mentioned all sorts of good benefits and good points about Ppli. Is it safe?
I think it's definitely very safe. I think that, there's been, there's a lot of scuttlebutt in different marketplaces about whether or not, creating private placement life insurance policies with anything other than mutual funds or hedge funds or specifically, established platforms is viable and doable. And I can tell you that, it's right out of the regulations that there are a variety of investments that can be made that qualify and that are eligible. With that said, one of the big developments that did occur in the last few months, and I sort of, I look at it, it affects both the captive area and it affects, believe it or not, the 419 AF6 marketplace that was there about, 20 years ago and went away with a notice 2007-83. There is now, right now, at least in the Sixth Circuit and probably passing, in other places, I think that there's a lot of rethinking of the issue of what is a listed transaction and what is or is not doable anymore, or will or will not be doable if the government thinks that something is potentially abusive. The answer is it's very safe, and it's probably safer now than it has been in the last, year and a half to 2 years of rhetoric being, promulgated on any kind of a warning-like basis. And the reason, as I said, there was a case called Mann Construction Corporation, which dealt with the invalidation of the 2007-83 notice as a de facto making of law without the necessary ability to comment being given to the practitioner community. So that was invalidated. And then there was the CIC services case, which was decided by a court within the Sixth Circuit, which basically said that the captive notice of 2016-66 and the subsequent making of it of all captives as a transaction of interest and consequently subject to listed transaction treatment or reportable transaction treatment, and the need for a Form 8886 and the need for a Form 8918 material advisor report both went away as a result of those things within that circuit. That's for sure. More than likely, the government will find another way. I think that what's going to actually happen is that they will no longer be able to take that cannon and, in the proverbial context, and take a shot across the bow at other ships to see what it is that they don't like and make them undoable. They'll have to be more in the way of legislation. But for the time being and for the foreseeable future, most definitely private placement life, as I described it, is a safe bet.
Thanks.
Let me just add a quick comment to that. It's a safe bet if you have someone that knows what they're doing. I've not done much with Ppli, and if I were to get involved, which I am actually right now with a transaction, I'd want some expert specialists involved. I don't think Ppli is like going out and doing an insurance trust. I think you need to be careful.
That's very true. Thank you, Marty.
From someone who's been in the business for as long as we have, that statement can't be truer. Yeah, Ppli is a world into its own. And Steve is one of the 3 people in the nation who can speak in that language. But Barry, we still have a few moments left. Are there any questions?
CLE code PL149 PL149.
I have a question.
I have a couple of questions.
So Steve and Henry, have you guys set up your slats yet, or are you in the process of doing it?
I have 2 slats. I have no wives anymore, but I have 2 slats.
But I think the point to everyone on the call is we got to take care of ourselves. It doesn't make sense to be the barefoot shoemaker. We should all have proper insurance in place. We should all have proper asset protection in place. We need to make sure we take care of ourselves like we take care of our clients. That was the point I was trying to make.
Absolutely.
Just on that point, Marty, I noticed that you're doing a webinar on blended families. I've been thinking of doing something like that for a while, but I saw that come across a couple of days ago. Wow, he is so on top of the pulse of what's going on and the feel of what people really need. You're always concerned about, being the technician and the expert that you are. But boy, sometimes most of the time, the ideas that you come out with are just so needed.
Thank you.
It makes so much sense.
I was guilty on this call, and I tried to address it by saying, there's different planning for people who are not married, because slats is really pretty much viewed as a married couple plan, but it's not. It could be for siblings or others too. The irony is that even though on most webinars, and I apologize, I didn't mean to be guilty of the same sin here, we talk about the Cleaver family as if that's the norm. And
far from the norm nowadays.
It's well in the minority. It's well in.
By the way, I wanted to ask you, Marty, on the webinar that you're doing. I think you're doing it with Mitchell and with Jonathan on the clawback, right? The question is, as far as there were a number of people who last year, I never actually did one, but I saw people who were making promissory notes and giving them to people as gifts. I'm assuming that those will be front and center in the what's clawed back type of an issue. If not to mention whether or not there's really a viable or enforceable promise.
So let me just explain in English what Steve said, because it may have been a little too sophisticated or unclear to some of you. Everything he said was correct, but if I have a $15 million estate, and in 2020 or 2021, oh my, they're going to reduce the exemption to $3.5 million. I better use up my exemption, but I can't give up my money. I got to have my money. I need beer money. So some lawyer came up to me and told me a creative idea. This is the hypothetical, folks. I'm just trying to make what he said simpler. You don't have to give up your stock portfolio, what you can do is you can we'll write up a legal document, a note, where you promise to make a gift to your kids of $10 million out of your $15 million, and you'll use up 10 million of your exemption, and you don't have to worry about repaying it until you die, but you've locked in 10 million of exemption in case the exemption goes down. The regulations the IRS just proposed, so it doesn't have the force and effect of law, basically says on that technique, which got a lot of talking about, it's not going to work, because when you die, you're not going to get the exemption amount when you did the loan, the promise of a gift. Rather, the exemption when you die is going to apply. So if the exemption gets cut by half, the whole plan just fails. Now, Steve very quickly had raised another issue. There was a legal issue as to whether or not that promise to make a gift is even enforceable under state law. I have not researched it. My understanding is that for some unknown reason to me, Pennsylvania law will permit a promise to be enforceable. It's less clear in other states. So Steve raised yet another issue: is does it even work legally? From a tax perspective, many commentators have speculated that the way the IRS talked about it in these proposed so-called clawback regs suggests that the technique does work. But the IRS is not commenting on state law, which, as Steve pointed out, is fundamental to knowing whether it works. They're commenting on it from a tax perspective. But it's all kind of academic, folks, because if the IRS says you don't get to lock in the higher exemption, it's all for naught. So if you have clients with that kind of planning, I would put them on notice that it may not work. And I mentioned some of the other things like busted preferred partnerships. There's a number of techniques that people used that basically were trying to have their clients have their cake and eat it too. So-called painless gifts, where you kind of used a gift and made a gift and locked in your exemption, but keep all your money. It goes back to when we were all kids. Remember, if it sounds too good to be true, it's probably not true. So.
Exactly. Thank you, Marty.